Good morning and thank you for joining today's webinar on post-implementation of an EMI. Good morning everybody and thank you for joining today's webinar on post-implementation of an EMI. Today's webinar is being hosted by myself, Caroline Parker, and my colleague Stuart Hale. The webinar will run for approximately 30 minutes and there will be an opportunity at the end to submit your questions. I'll now pass you over to Stuart to begin.
So, today I'll be discussing disqualifying events in a post-implementation context. When the plan is established as part of the implementation process, the requirements for qualifying for EMI will be checked. However, what is often misunderstood or forgotten by clients is that this is an ongoing obligation. Certain events will result in your EMI plan becoming disqualified, resulting in the loss of tax advantages for both the participants and for the company. Alternatively, the company may no longer be able to grant qualifying EMI options for the future. Accordingly, the company needs to keep checking on its position, both to ensure ongoing compliance and also to avoid the risk of a historical disqualifying event being uncovered during due diligence on a sale when it is too late for remedial action to be taken. Recently, I attended a talk on corporate actions being given by a large London law firm. And in the section relating to private company sales, there was a considerable amount of time spent noting the fact that companies were often not in compliance with the EMI code and the various ways that they may be falling down in this area. The speakers noted that more often than not, a selling company found themselves in the unfortunate situation that their EMI options were not in fact tax advantaged due to a disqualifying event having taken place. And it's important to remember that law firms negotiating sales and purchases of companies will be very hot on this topic. Now, I've included a slide which is a brief reminder of the main EMI qualifying requirements for completeness, but in fact I will not be dwelling any further on this slide at this point because my post-implementation focus requires a slightly different emphasis. Broadly speaking, there are 6 main areas to consider further in this regard: independence, trading activities, qualifying subsidiaries, gross assets, number of employees, and participant eligibility. Moving on to substance, the first area that I want to delve into today relates to independence. A company whose shares are subject to EMI options must not be 51% subsidiary, i.e. more than 50% of its ordinary share capital owned by another company, or controlled by another company or another company and persons connected with it, and arrangements must not exist which could result in the company being a 51% subsidiary or otherwise being controlled by another company. Accordingly, it is necessary as part of an ongoing compliance process to seek out answers to the following questions. Have there been any changes in the company's share capital or ownership structure? For example, have there been any new investments made, particularly by corporate investors? Has the company made any changes to its articles of association? Has the company entered into any shareholders agreements or investment or joint venture agreements? Or has it made any changes to existing agreements? In relation to connected parties, let's consider the diagram on the slide. Here, Bob owns 40% of the shares in Company B, and Company A owns 40% of Company B. This is no problem from an independence perspective. But what if, instead of the position on the previous slide, it transpires that Bob, as well as owning 40% of Company B, also owns 100% of Company A? In this situation, Bob and Company A would be treated as connected persons, and the independence requirement would not, in fact, be met in this scenario. Recently, we had a case where an individual owned 50% of the company, the shares of which were to be placed under EMI option, and it transpired that the remaining 50% of the shares were owned by a company which was in turn owned 100% by his father. In addition, there was a shareholders agreement which was largely vanilla in nature, as being a 50-50 joint venture, but did contain an option whereby the individual could buy back shares from the company based on certain milestones. I'm not embarrassed to say that we placed that decision firmly in the hands of HM Revenue and Customs Small Companies Enterprise Centre, and they provide a helpful advanced clearance process in cases involving difficulty and considerable uncertainty. So what of arrangements? Well, my view is that this is a common sense test. Plenty of companies with external funders have entered into arrangements giving the funders the right to control in particular situations. But realistically, these will only apply in a disastrous scenario and exist as an emergency protection for the investor. HMRC are unlikely to view this as an arrangement because the chances of the company losing its independence are extremely remote. On the other hand, entering into realistic discussions with a potential acquirer is likely to render any purported subsequent EMI grant to be an unqualified option. Certainly, entering into heads of terms is highly likely to be considered by HMRC as arrangements in existence. And RM2's view is really that if the action to be carried out does not fall within the spirit of the EMI legislation, by that I mean which is to provide a tax advantage method for providing small, fast-growing independent companies to recruit and retain employees, then there is a risk of a disqualifying event having occurred. In relation to trading activities, well, has the company's trade changed, and perhaps changed to an excluded activity? Linking to this point, does the company receive royalties or other license fees? RM2 have recently had a couple of examples where it has been necessary to look very carefully at licensing arrangements that have been entered into, as activities involving royalties and license fee arrangements can, in certain circumstances, constitute excluded activities for EMI purposes. In relation to financial services and the excluded activities of banking and finance, the HMRC Venture Capital Manual notes that other financial activities that are excluded are those in particular involving the lending of money or the bearing of customers' financial risk. Yet, it is also noted in the same manual that the provision of financial services such as the advice on financial matters is not covered by the exclusion. So as you will appreciate, there may be situations where there is no black and white answer. Turning to insurance, a question which sometimes occurs in relation to the provision comes up in relation to the provision of insurance broking services. Now this is because there is the possibility in relation to insurance broking services of these being treated as actually providing insurance, particularly where the brokers can themselves accept insurance risks on behalf of a client's insurance company, i.e. Lloyd's syndicate or large insurance provider, and or they may have the ability themselves as brokers to settle claims on behalf of their clients. In relation to qualifying subsidiaries, what I'd like to say is, well, all of the company's subsidiaries must be qualifying subsidiaries. That is, the company whose shares are subject to the EMI option must hold directly or indirectly more than 50% of the share capital of the subsidiary. Therefore, if a company enters into a 50-50 joint venture or acquires a non-qualifying subsidiary, those events will not cause the existing EMI options to lose their tax status, but they will preclude the company from granting any more EMI options. And I think the simplest way of considering this further is by way of some scenarios. Clearly, where an EMI company holds 51% or more of the share capital in a subsidiary, it's reasonable to assume that the EMI company will qualify for EMI, unless in extremely unusual circumstances where that share ownership did not in fact give control. So it would be necessary to have reviewed any shareholders' agreements, etc., to confirm whether or not that was the case. However, if the EMI company holds less than 50% of shares in another company, this may be viewed not as a subsidiary, but possibly as an investment by HMRC, which may again preclude EMI qualification on the basis of the trading activities test. So where there is no control, then HMRC might treat this scenario as a pure investment. Now, this is permitted within the rules, but we need to show that this investment was basically either insubstantial or insignificant. Now, if there's no attribution of any value to this investment on the balance sheet, this suggests that it is an insubstantial investment. However, it's still necessary to seek answers to a couple more questions in this regard. For instance, does the EMI company receive any dividends, profits, or other financial benefits out of this arrangement with the joint venture company? If it does, then this obviously can make the arrangement more significant. What is the purpose of the arrangement? Is it to provide access to markets or services, or an opportunity to make profits on the share of the sales? Or is it relating to some loan arrangements? When you believe that an arrangement might be insubstantial or insignificant, RM2 would still recommend clearing these arrangements with HMRC just to be on the safe side. Because at the end of the day, whether a clearance will be obtained will depend on the particular circumstances of the case. Whether it's a joint venture company with shares in the subsidiary being held 50-50 between the EMI company and another company, you'll likely need to review the shareholders' agreement to identify either whether any one party has control, or if not, whether the parties are acting together. Again, RM2 would also advise seeking clearance from HMRC and dealing with this scenario. But effectively, if the JV company counts as a subsidiary, it won't be a 51% subsidiary because it's a 50-50 joint venture, and therefore on the face of it doesn't qualify. But the JV company will count as a subsidiary if it is controlled by the EMI company and another person connected with the EMI company. And generally, companies are connected if in relation to a company, two or more persons acting together to secure or exercise control are connected. However, are these two parties in fact acting together to secure or exercise control? And if the two parties are not acting together to secure control, then the two parties are not connected. And if the two parties aren't connected, then the JV company is not controlled by the EMI company and another person connected with the EMI company, and therefore the JV company is not a subsidiary. So, when we're looking at this, you need to also consider the matter of the shareholders' agreement, and at that level, rather than the board level control of day-to-day affairs. This is because when we're analysing whether persons are acting together, this is usually determined by reference to the terms of the JV agreement according to case law. And the control test, which is contained in sections 450 to 451 of the Corporation Taxes Act 2010, looks at whether the person or two or more persons acting together are entitled to acquire control over a company's affairs by, for instance, acquiring greater part of share capital or the assets on a winding up. So clearly the test relates to shareholders in general meeting rather than board control. And also Lord Hoffman, in one of the leading judgments, described the net covered by this test as being cast enormously wide. So shareholders observing the terms of the 50-50 joint venture or shareholders agreement will be acting together. However, mere aggregation of shareholdings is not necessarily sufficient for shareholders to be acting together, and RM2 have had correspondence with HM Revenue and Customs on this point. In relation to the remaining post-implementation disqualifying points, first one on gross assets. Well, as we all know, the value of the company's gross assets must not exceed 30 million at the date the EMI option is granted. And if the company is a member of a group of companies, the limits are applied to the gross assets of the group as a whole. If the gross assets increase above this threshold in the future, it will prevent new EMI awards being granted, but will not disturb awards already being made. So I would say keep an eye on your balance sheet in this regard, so you don't miss an opportunity to make awards before you breach this limit. And does the company employ more than 250 full-time, including full-time equivalent employees, or is that likely in the near future? The company clearly has to have fewer than 250 employees, including full-time equivalents, in order to be able to grant EMI options. And the number of employees requirement applies to employees of the company and all of its qualifying subsidiaries, whether or not they're based in the UK. Directors are counted as employees for the purposes of this test, but apprentices, students on vocational training, and employees on maternity or paternity leave at the time the option is to be granted and not to be counted. So if the employee headcount increases above this threshold in future, this will, as I've said, prevent new EMI awards being granted, but will not disturb awards already made. So keep an eye on your staff numbers so you don't miss an opportunity to make awards before you've reached the limit. Another thing to bear in mind is, do all your existing EMI participants still work full-time, or the majority of their working time for the company? And don't forget, participants must be employees and not non-executive directors or consultants. An eligible participant is an employee who works at least 25 hours a week for the company or spends 75% of their total working time employed by the company. And shareholders holding 30% or more of the equity in the company at the date of grant cannot be awarded options under the EMI, or those connected to them, e.g. a spouse, parent or child. And persons on sabbatical can catch employers out in this regard, as granting a sabbatical to an EMI option holder may result in a disqualifying event. And here is where I pass the baton over to Caroline to continue.
Thank you, Stuart. So I'm just going to talk a little bit about what happens once the EMI plan is established. So that is when the documents for the first award have been executed and the participants have their options. So what happens next? I've split it into 4 areas: the registration of the EMI plan itself as a whole, the notification to HMRC of the options that have been granted, so that's the specific grant details, the annual return, and then the general record keeping of the plan and the ongoing administration. So the first task is to tell HMRC that the EMI exists. In 2014, HMRC launched employment-related securities, which moved share scheme records from a paper platform onto the online platform. Previously, HMRC relied on companies completing an EMI-1 form, or known as the Notice of Grant. The ERS service is accessed online, which is attached to the existing PAYE online services that a company may already use. So to register an EMI, the company must have what is known as an organisations account. So this is an account that is accessed by the company and not an agent. So an agent may be an advisor of the company, such as an accountant or a share scheme specialist. If the company's affairs are purely dealt with by an agent, they will need to open an organisation account for this purpose. So in terms of the online service, HMRC will only allow a company, so an organisation, to register their own EMI plan. If you have an agent, they cannot do this. The functionality is not there for an agent to do this, although obviously an agent can guide an organisation on how to do this. The company has to register the plan because they are the ones declaring that the EMI has been designed in line with the legislation. If the company does wish to outsource the ongoing administration, they can do so by providing their PAYE and accounts office reference to their agent. The agent then uses their own online access to seek authorisation from the company via HMRC that they are appointed as an agent for this specific purpose. It is important to note that the references that the company provide to their agent must be the same references that they use to access their own online account on which they registered the EMI. The appointment of a specific employment-related securities agent will not affect any other agent's access that you use. The company may have several agents, so they might have their accountants dealing with their PAYE, and as I said, a specialist share scheme provider looking after their EMI records online. But an ERS agent cannot actually access the company's PAYE information, so there's no interference on that side of things. So once the plan is registered, you then need to notify HMRC within 92 days of the date of grant about a specific award that has been made. So HMRC will want to know the details of the grantor of the options, so the top company, things like the registered office of the top company and their company registration number, the date of grant, the employer of the particular participant that you've granted options to. They ask if the shares are under a class of share that is already in the issued share capital. They ask things like, does the company have more than one class of share in its issued share capital? Is the company listed on a recognised stock exchange? So that would mean fully listed. AIM, for the purpose of HMRC, is not a recognised stock exchange. They ask for the details of the unrestricted market value per share, which is relevant for the £250,000 participant limit and the company's £3 million limit of options that you can award. And they also ask you details about the valuation and if you sought agreement from shares and assets valuation. In terms of the participant award data, they'll ask then for their name, their national insurance number, number of options, the exercise price at which the options were granted, the actual market value per share, and again the total UMV that applies to that particular participant. Currently, there is not a way to correct an incorrect registration of options online with HMRC. We have contacted HMRC about this, and they provided a solution whereby if you submit the wrong information, you then would go back into the system, submit the correct information, and the way you correct that is by way of the annual return. So when you come to do the annual return, you would make your adjustments to ensure that the revenue didn't log 2 lots of options. So an example of this would be you award options to 10 employees and you have an exercise price of £10. When you come to register those options, you incorrectly state that the exercise price was actually £1 when you should have said £10. You do this for all 10 employees. To correct this, you submit the whole new registration stating the correct exercise price of £10. And when it comes to completing your annual return, you would lapse the first set of options where you incorrectly stated that the exercise price was £1. Now, this isn't an ideal way of amending a submission, but currently it is the only way of amending the incorrect registration of options. Coming on to the annual returns that must be filed each year. So at the beginning of each tax year, the company is responsible for submitting to HMRC the EMI return, and this basically informs HMRC of anything that may have happened in the tax year, such as lapses, exercise events, disqualifying events. And what they must do is they must submit the annual return online to HMRC by the 6th of July following the tax year in which it applies to. So there are some other important dates that a company or its agent must adhere to. So as previously mentioned, the company has 92 days from the date of grant to register the options. If they fail to register them within this time, it could result in the EMI options losing its tax advantages. And as just mentioned, with the annual return, you must inform the revenue by way of the annual return by the 6th of July, submitting that online, and failure to submit the return on time will result in automatic penalties being issued and can also result in some cases in the loss of the tax advantages. So I'm just going to talk about the record keeping, so the administration side of things, and what a company or its agent should be doing to ensure that the EMI retains all of its intended tax advantages. So the company or the agent, whoever's dealing with it, should ensure that the participants and the company hold a copy of the fully signed option agreements. The company should hold the originals, we would usually say, and all parties should hold a copy of the rules and any other supplementary documents that were issued with the documents, such as frequently asked questions. The participants are entitled to request a copy of the Articles of Association, and the company should provide them should they be requested. You may have approached the revenue before the grant of the options to obtain a valuation agreement from HMRC. It's really important that the submissions to HMRC and any agreements or further correspondence is held safely on file for future reference. In terms of filing the option awards and registering the EMI online, HMRC issues receipts and acknowledgement references. These should be printed off and saved in hard and soft copy, and any receipts for the annual returns. There's a specific receipt that the HMRC will issue on successful submission of an annual return. These should all be kept in a safe place, all together with the grant documentation. In terms of maintaining the records, the company or its agent should establish a register of the options, and it should capture information such as participant name, national insurance number, the date of the grant of the options, the number of the options that were granted, including the type of share, the exercise price. A note of the vesting conditions in one place is always helpful, and any automatic lapse dates. We also would suggest that updated addresses of the participants are kept just for ease of reference. Should their options lapse and you need to notify them, you have their updated details to hand. In terms of leavers, we would always suggest that leavers are recorded on a timely basis. You may have a leaver that is entitled to exercise, and you have 90 days in which to do that to ensure that the tax advantages are retained. You should be aware of what happens to their shares if they leave for various reasons, and this information is relevant for the annual return, so it should be kept up to date regularly. So that brings us on to the summary of our webinar today. We've identified that the post-implementation checks and the administration of an EMI plan over its entire lifetime are really crucial to preserving its favourable tax treatment. The company or an appointed agent must keep checking its position as part of an ongoing compliance process. If not, it may be too late for remedial action to be taken. In relation to disqualifying events, technical issues can arise, but HMRC are on hand to assist in resolving more technical issues. The post-implementation tasks are just as crucial as getting the design elements right, and the administration is integral to ensuring that both the company and the participants reap the intended awards. A third-party acquirer will expect a company to have its share records in good shape as part of any due diligence process, and maintaining the register for the life of the plan really is essential to this process. So you need to keep the share plan records in order, and you need to keep the documentation in a safe place. We'd now like to offer the opportunity to ask any questions, and you can do that by entering your question to the right-hand side of your screen. We just have a question here. So we have one question: does it take long to register your EMI? We found that the process really depends on how in order the company has their references and things in order. So in order to, if they already have a PAYE online account, it's relatively straightforward because the employment-related securities module can be found within the PAYE section, and it literally is a case of going through, following the on-screen instructions to get the EMI registered. HMRC I think it says a couple of days. They'll come back with the acknowledgement reference and a scheme reference number. Often it is much quicker. So depending on where you start in the process, if you don't have a PAYE account, it can take a number of weeks, and that is because the revenue have their set procedure for issuing account usernames and IDs and passwords, and there's also an activation code involved. So it really depends on that process and where you're starting. So we have a question here that the point we were making about correcting an incorrect notification won't work if the subsequent correct notification means that the overall £3 million limit would have been exceeded, or the individual limit has it been exceeded. How do you get around this? The only guidance we have received from HMRC is that you must register the options on time within the 92-day limit. The system certainly wouldn't stop you from exceeding the limits. They would come back and question them, but if that is the case, our guidance today is that you just have to make that subsequent correct notification to HMRC, and if you receive correspondence in the meantime from them stating the limits, you can explain that actually it will be corrected by way of the annual return. That's the guidance we've received from HMRC to date. They haven't put an amendment function in, so this is the only option they've given us to correct incorrect registrations. Sorry, we're just reading through the questions. Sorry, they're just a bit difficult to view. I can't. Someone was asking about the fine on failing to make the return on time. There are automatic fines in place, and they start at £100, I believe. And then as time goes on, if you exceed, it's 9 months, they become daily charges, so it can become very expensive for a company.
And we've had a question in asking for confirmation that entering into a non-binding head of terms is not a disqualifying event for existing options. I mean, essentially, what would happen is that if the head of terms you had entered into, and I think the revenue don't necessarily hold the same view about non-binding and binding heads of terms. If their view is the heads of terms are a disqualifying event, then you will have the usual time after the disqualifying event to exercise your options in a tax advantage matter, and that should occur within the time frame of your transaction. So essentially, where that happens, you would be able to get your tax advantages for existing options. So the question would be more about any purported grants at around that sort of time.
And another question has been, if you fail to, if the company fails to notify within 92 days, what are the consequences, and how do you rectify the position? And there is the HMRC will allow you to almost submit an appeal. So an appeal for if you have a reasonable excuse as to why the 92-day limit was not met, and they will just consider that. You just submit it to them in writing, and they will consider if they think the options should then be accepted as EMI options. So we're just we're going to wrap it up there. If there are any more questions, our email addresses are on the slide. Please feel free to contact us, and we'll get back to you as soon as we can. Thank you for joining today's webinar, and you will receive a follow-up survey from SurveyMonkey. If you could please take a few minutes to provide feedback, we would really appreciate that. Thank you.
Thank you.